have you ever found yourself really wondering who holds the power when it comes to your fundamental rights? Or, how those precious rights are safeguarded from laws that might try to quietly chip away at them? It's a profound question, isn't it? One that touches the very core of our daily existence, shaping everything from local governance to national policy, even if we don't consciously think about it every single day. Well, today we're taking a deep dive into some of the most foundational and powerful parts of the Indian Constitution, Articles 12 through 16. These articles aren't just dry legal text. They lay the essential groundwork for what's meant to be a truly just and equitable society. They define who is accountable for upholding your rights and how those rights are protected before we plunge into the very essence of equality itself.
Indeed, these articles are like the sentinels of Part 3 of the Constitution, which enshrines your fundamental rights. They really stand guard. We'll be exploring the critical definitions that set the stage for all rights, the intricate mechanisms that act as constitutional shields against their erosion, and then the nuanced, multifaceted principles that truly underpin the right to equality in India. This isn't just about what's written, it's about how it lives and breathes in our democracy.
Our mission today is to unpack these crucial articles, helping you understand not just who is bound by these rights, but how they're protected from being eroded and what equality genuinely means in the Indian context, which, as you'll see, goes far beyond simply treating everyone the same. It's much more layered than that. It's about empowering you with knowledge, giving you a shortcut maybe to being well-informed about the bedrock of your rights and how they shape your world.
We aim for those genuine aha moments, connecting complex legal concepts to real-world scenarios you might encounter, or significant situations you've heard about in the news. Our goal is that you walk away not just informed, but genuinely enlightened about the very fabric of your constitutional protections and how dynamically they apply to you.
Whether you're prepping for a meeting, catching up on a fascinating field, or just insanely curious about the bedrock of Indian democracy and your place within it, well, this deep dive is for you. So let's peel back the layers and get started.
Article 12, defining the state.
Right, so we've established that we're talking about fundamental rights. But before we can even begin to understand those rights, we need to know who they apply to and, crucially, who can be held accountable if they're violated. That's where Article 12 steps in, giving us the foundational definition of the state. Why is clarifying who the state is so absolutely fundamental to understanding our rights?
It's foundational because without a clear definition, these rights would be mere paper tigers, wouldn't they? Just words on a page. What's fascinating here is that Article 12 provides an inclusive rather than exhaustive definition. It's designed to cast a really wide net. This ensures fundamental rights can be claimed against a vast array of entities beyond just the central government, reaching down to local bodies and even quasi-governmental organizations. This expansiveness is key, absolutely key, to effective and pervasive rights protection across the entire system.
Okay, so let's get the exact wording out there for everyone. Article 12 states, in this part, unless the context otherwise requires, the state includes the government and parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the government of India. Quite a mouthful, but packed with meaning.
It is. So let's break down those basic ingredients. First, we have the obvious and traditional centers of power, the government and parliament of India, meaning the executive and legislative arms of the Union, and then the government and legislature of each of the states, covering the executive and legislative organs at the state level. These are clearly accountable, no surprises there.
Right, that's the straightforward part. But then we move to local authorities. What falls under that?
These are the bodies we interact with daily at a grassroots level. Think about your municipal corporations, district boards, panchayats, improvement trusts, all those local bodies. They are recognized by law and have a degree of autonomy. Their inclusion here is vital for local governance accountability.
So if your local council, say a municipal corporation, makes a bylaw that arbitrarily restricts your freedom of speech in public parks, perhaps banning all public gatherings without good reason, that action can be challenged as a violation of your fundamental rights, because the municipal corporation is state.
Precisely. The municipal corporation is definitively state under Article 12. That's a direct impact on your everyday life, right down to your neighborhood park. The framers understood that governmental power is often decentralized, and constitutional accountability must follow it wherever it goes.
Makes sense. But then there's that phrase, other authorities.
Yeah.
That sounds potentially massive.
Yes, other authorities. Here's where it gets really interesting and where the courts have played an immense role. This phrase has been a subject of intense judicial scrutiny. It's transformed over decades from a very restrictive interpretation to a much more expansive one, making the Constitution truly alive and adaptable.
It does sound broad, almost vague initially. So how did the courts first grapple with it? What was the early thinking?
That's a great question because initially the courts took a very cautious, almost narrow approach. For instance, in early cases like University of Madras versus Shantabai back in 1954, the Madras High Court suggested that other authorities should be interpreted adjustum generis. Think of it like a shopping list. If I say apples, oranges, bananas, and other produce, you'd naturally assume other produce means more fruits, not, say, electronics.
Okay, so of the same kind.
Exactly. That's how courts first interpreted other authorities' only bodies, like government functions, essentially performing governmental or sovereign tasks. This initial restrictive view meant many powerful public bodies were at first outside the net of fundamental rights accountability. Even the Supreme Court in Ujambai versus State of UP in 1962, while broadening the view somewhat, the majority still leaned against statutory bodies not performing sovereign functions being considered state.
So if it wasn't clearly performing a direct government function, it wasn't state, that seems like it would leave a lot of bodies off the hook and limit the reach of fundamental rights quite a bit.
It did. It really did. But then came a pivotal moment that dramatically changed the landscape. In Rajasthan State Electricity Board versus Mohan Lal in 1967, the Supreme Court unequivocally rejected the adjustum generis rule. That was a game changer. It held that other authorities includes all authorities created by the Constitution or by statute with legal powers, regardless of whether they perform governmental or sovereign functions. This dramatically widened the scope of accountability. It made it clear that fundamental rights could be enforced against a much broader range of statutory bodies.
So the net suddenly widened significantly. But if it's not explicitly governmental, how do you actually decide if a body is an authority and thus part of the state? Is there, like, a practical checklist for this expanded definition?
That's precisely where the instrumentality or agency test came into play, refined over several landmark judgments. This doctrine looks at the substance, not just the form, to determine if a body acts as an arm of the government. It asks, is this entity essentially doing the government's work? In Sukhdev Singh versus Bhagatram Sardar Singh Raghuvanshi in 1975, the court held that statutory corporations, like the Life Insurance Corporation, LIC, Oil and Natural Gas Corporation, ONGC, and the Industrial Finance Corporation, IFC, are state. This was a significant expansion, bringing massive public sector undertakings under the ambit of fundamental rights accountability.
Wow, that immediately brings fundamental rights into play for millions of employees and citizens interacting with these massive organizations. This feels like a huge aha moment for many listeners, realizing that their rights extend to these public bodies.
Absolutely. It connects the Constitution directly to these powerful entities. Then, in R.D. Shetty versus International Airport Authority of India in 1979, Justice P.N. Bhagwati laid down 5 specific tests to guide this determination. It's quite helpful. These tests look at 1, whether the state's financial resources are the chief funding source.
Right, follow the money.
Exactly. 2, the existence of deep and pervasive state control. How much does the government actually run things? 3, the functional character being governmental in essence, implying functions of public importance. Is it doing something only a government usually does, or something vital to the public? 4, whether a government department has been transferred to the corporation. Did it used to be a ministry, now it's a corporation? And 5, whether the corporation enjoys monopoly status conferred or protected by the state. Does it have exclusive rights given by the government? These provide a robust, practical framework for assessment, not just one factor, but a combination.
And these tests were then reiterated and solidified over time. They weren't just a one-off.
Oh yes, definitely solidified. Ajay Hasia versus Khalid Mujib Saravardi in 1981 reaffirmed these R.D. Shetty tests and, importantly, extended their applicability to registered societies, broadening the net even further. Think educational societies, research institutions. Further, in Pradeep Kumar Biswas versus Indian Institute of Chemical Biology in 2002, a 7-judge bench overruled a previous decision and held that the Council of Scientific and Industrial Research, CSIR, is state. The court emphasized that the core question is whether the body is financially, functionally, and administratively dominated by or under the control of the government. This case truly solidified the expansive interpretation, demonstrating that the inquiry is always about the real control, not just the legal facade.
But the courts don't just say everything is state, right? There must be limits to this expansive definition. It can't be that every organization receiving some government grant is state.
That's a crucial point, and it brings us to a contrasting case. Z Telefirms Ltd versus Union of India in 2005, a very important clarification. Here, the Supreme Court held that the Board of Control for Cricket in India, BCCI, is not state under Article 12. It found that the BCCI didn't meet the criteria of being financially, functionally, or administratively dominated by the government, nor was it an instrumentality or agency of the state, despite regulating cricket nationally. This demonstrates that the tests are applied rigorously, and not every public-facing body automatically qualifies. It shows the judiciary's careful balance. It's not a blanket rule.
What about the courts themselves? Are they state under Article 12? This raises an interesting, almost recursive question. Can the judiciary violate fundamental rights?
This does raise an important question, and the answer is nuanced. When courts perform their core judicial functions, that is, when they're delivering judgments and interpreting laws, they're generally not considered state for direct challenges under Article 12 for fundamental rights violations within their judgments. Their role there is to interpret and enforce the law, including fundamental rights against others. However, when courts make rules for their own administration, make administrative decisions, or act in a non-judicial capacity like managing their own staff, procurement, or determining service conditions, then they can fall under the division of state. It's a distinction between their judicial role and their administrative role.
Okay, that makes sense. So, to make this even clearer with a few more practical illustrations, imagine these scenarios for yourself. If a municipal corporation's bylaw restricts free speech without good reason, that action can be challenged under fundamental rights because the corporation is state. We established that. Or if you faced an arbitrary termination from a public sector undertaking like LIC or ONGC, assuming it's deemed state based on those tests we discussed, you could challenge that action in court under your fundamental rights. Even an Indian government authority operating abroad affecting Indian citizens would be considered state and its actions challengeable. The reach is quite wide. So what does this all mean for you, the listener? Article 12 ensures that your rights are not just theoretical promises, but incredibly real and enforceable against a vast network of public and quasi-public bodies that wield significant power. It's the foundational step in making fundamental rights a practical reality, protecting you from both direct government actions and the actions of many other influential bodies. It defines the arena.
Article 13, the Shield of Fundamental Rights.
So we've identified the players, the state, the ones accountable for upholding your rights, thanks to Article 12. But what about the rules of the game itself? What shields those rights from being trampled by new laws or even old ones that linger from the past? That brings us to Article 13, the ultimate guardian, acting as a powerful constitutional shield, ensuring that no law, no matter its origin, can arbitrarily cut into your basic freedoms.
Article 13 is, quite simply, the bedrock of judicial review in India concerning fundamental rights. It's the constitutional muscle. It explicitly declares that any law, past or present, that is inconsistent with or takes away fundamental rights will be void, full stop. It acts as a clear and unambiguous warning to the legislature. Your power to enact laws is always subservient to the fundamental rights enshrined in the Constitution. It's the Constitution protecting itself and, by extension, your rights.
Let's lay out the precise language of this critical article, maybe break it down a bit. Clause 1 states, all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. So, old laws clashing with new rights, they're out, at least the clashing parts.
Exactly, to the extent of the inconsistency. Clause 2 then mandates, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. This is the forward-looking prohibition. Don't make laws that hurt these rights.
And Clause 3 gives a really wide definition of law and laws in force, right?
Extremely wide. Clause 3A says law includes any ordinance, order, bylaw, rule, regulation, notification, and crucially, custom or usage having in the territory of India the force of law. And B, clarifies laws in force, includes laws made before the Constitution.
Then there's Clause 4, which came later.
Yes, Clause 4, inserted by the 24th Amendment in 1971, states, nothing in this article shall apply to any amendment of this Constitution made under Article 368. We'll definitely come back to why this was added and its huge implications.
Okay, so let's break down those types of laws and their fate under Article 13. Pre-constitutional laws first.
Right. For pre-constitutional laws, those covered by Article 13.1, laws existing before January 26, 1950, become void to the extent of inconsistency from the Constitution's commencement. They are not void ab initio, meaning from the beginning, but merely become unenforceable from that date onwards. This is an important distinction because it means transactions completed under those laws before 1950 are still considered valid. Imagine a colonial-era law that was fine until the Constitution arrived. It just went dormant, not erased from history entirely.
And for laws made after the Constitution came into force, what's their fate if they clash with fundamental rights?
Post-constitutional laws, under Article 13.2, face a much stricter fate. The state is expressly prohibited from making laws that take away or abridge fundamental rights. Such laws are void ab initio, meaning void from their very inception to the extent of the contravention. This provision acts as an immediate and powerful check on legislative power. If Parliament or a state legislature tries to pass a law today that violates your fundamental rights, it's considered non-existent from the moment it's enacted, not just unenforceable later. It's dead on arrival, legally speaking.
Now, that wide definition of law in Article 13.3 you mentioned, it includes custom or usage having the force of law. That sounds incredibly significant.
It is critical and often overlooked. Law isn't just parliamentary legislation or state assembly enactments. It includes ordinances, orders, bylaws, rules, regulations, notifications, basically, all forms of delegated legislation. But yes, the truly transformative part is including custom or usage having the force of law. This broad scope allows fundamental rights to challenge even deeply entrenched social practices that might have quasi-legal status in some communities.
So even a long-standing tradition or a village custom, if it effectively functions like a law in that community, can be challenged if it violates your fundamental rights. That's powerful. It means constitutional principles can reach into the very fabric of social norms and traditions. Imagine a community custom denying women the right to inherit property. If proven to have the force of law and found to violate Article 14 or 15, it could be declared void under Article 13. That's a huge step towards modernizing society through constitutional means.
Exactly. It's a constant constitutional pressure towards reform and aligning social practices with fundamental rights. And then we have Article 13.4. This clause, inserted by the 24th Amendment in 1971, explicitly states that Article 13 doesn't apply to constitutional amendments made under Article 368. However, and this is the big, however, we take this to the bigger picture, this provision itself became a central point in the basic structure doctrine, which we absolutely need to delve into. This seemingly simple clause ignited one of the greatest constitutional battles in India's history.
Okay, before we get to that battle, what are the key doctrines or legal principles that emerge from Article 13? Beyond just the raw text.
Right. Several important doctrines flow from Article 13. First and foremost, we have judicial review. Article 13 provides the explicit textual basis for courts to strike down laws violating fundamental rights. It empowers the judiciary. It also establishes the clear supremacy of fundamental rights over all other forms of law as defined in 13.3. Then the principle of voidness to the extent of inconsistency contravention introduces the doctrine of severability.
Severability, like you can sever the bad part.
Precisely. It means if only a part of a law violates fundamental rights, and that part is separable from the rest without destroying the law's overall purpose, then only the offending part is declared void, leaving the remainder of the law intact. It prevents throwing out the baby with the bathwater, so to speak. Sensible approach.
This next one sounds almost poetic. What's the doctrine of eclipse?
Ah, yes, the doctrine of eclipse. It's a fascinating concept, isn't it? Think of it this way. A pre-Constitution law that was inconsistent with fundamental rights was like a light bulb that worked fine before the new modern power grid the Constitution came on. If it didn't fit the new wiring, that is, it clashed with fundamental rights, it just went dark. It was eclipsed or overshadowed by the fundamental right, not destroyed entirely. It remained in a dormant state and could theoretically revive if the inconsistency was removed, for instance, by a constitutional amendment that made it compatible again.
So potentially, it could come back to life.
Theoretically, yes, for pre-constitutional laws. But, and this is crucial, a post-constitution law that violates rights. That's like building a faulty light bulb from scratch. It was never really on in the first place. It's void ab initio, completely null from the start, and cannot simply revive if the conflicting fundamental right is later amended. It's considered stillborn. This distinction between pre- and post-constitutional laws under eclipse is critical.
Okay, so to give you a clearer picture, Imagine a colonial-era law mandating segregation in public transport based on race. Upon the commencement of the Constitution, this law, being inconsistent with Article 15's prohibition of discrimination, would become void under Article 13(1). To the extent of this inconsistency, it's eclipsed. However, if a new law were passed today that arbitrarily restricted free speech, that would be a void ab initio under Article 13(2). It's a critical and practical distinction for how laws are treated. Now, Article 15 has been at the heart of some of India's most significant constitutional battles, particularly around Parliament's power to amend fundamental rights. Can you guide us through that epic evolution? It sounds like a real constitutional drama.
The journey of Article 13 has indeed been epic, a testament to the dynamic nature of constitutional interpretation. It wasn't a straight path at all. Early on, in Keshavan Madhava Menon v. State of Bombay in 1951, the Supreme Court held that Article 13(1) is prospective, meaning it doesn't invalidate pre-constitutional laws for the period before the Constitution. It doesn't work backwards. Baram Khurshid Pasika v. State of Bombay in 1955 elaborated on the doctrine of eclipse, confirming its application to pre-constitutional laws. Then Deep Chand v. State of UP in 1959 clarified that the doctrine of eclipse does not apply to post-constitutional laws, as they are void ab initio, they simply cannot be revived. That solidified the distinction. The real constitutional drama, however, began with a burning question. Could fundamental rights themselves be amended by Parliament under Article 368, or did Article 13 act as a bar? In cases like Shankari Prasad Singh Deo, 1951, and Sajjan Singh, 1965, the Supreme Court initially held that the term law in 13(2) does not include constitutional amendments made under Article 368. This essentially gave Parliament unlimited power to amend any part of the Constitution, including fundamental rights, without them being subject to judicial review under Article 13.
Wow. So Parliament could essentially change the Constitution and potentially bypass fundamental rights. That sounds incredibly risky for individual liberties.
That was the initial interpretation, and it understandably caused significant concern among constitutionalists and citizens alike. It seemed to place Parliament above the fundamental rights chapter. But then, in I.C. Goleknath v. State of Punjab in 1967, a larger 11-judge bench famously overruled these previous decisions. It took a dramatically different stance. It held that law does include constitutional amendments. Therefore, Parliament could not amend fundamental rights if the amendment abridged or took them away. This created a direct and dramatic conflict between parliamentary sovereignty and the supremacy of fundamental rights, leading to a huge constitutional showdown.
Okay, so Goleknath said Parliament can't easily amend fundamental rights. But Parliament pushed back, right? Leading to the 24th Amendment and Article 13(4).
Exactly.
Yeah.
Parliament responded swiftly with the 24th Amendment in 1971, which added Clause 4 to Article 13, stating that Article 13 does not apply to constitutional amendments. It also amended Article 368 to reinforce Parliament's amending power. Parliament was essentially saying, yes, we can amend fundamental rights.
So the stage was set for another major confrontation, and this led to what's often called the most significant constitutional case in India's history, right? Kesavananda Bharati.
Absolutely. This was the ultimate showdown. Kesavananda Bharati versus State of Kerala in 1973. It was heard by the largest bench ever assembled in the Supreme Court, 13 judges, and the judgment profoundly shaped Indian democracy forever. While it actually overruled Goleknath on the point of whether law in Article 13 included amendments, it agreed with Parliament that it didn't, upholding the 24th Amendment in Article 13(4), it propounded the revolutionary doctrine of basic structure. This isn't just legal jargon. It's a constitutional safeguard that says even Parliament, with all its power under Article 368, cannot alter the very basic structure or framework of the Constitution.
The basic structure. So even if Parliament follows the procedure in Article 368, there are some fundamental things about the Constitution they just can't touch.
That's the core idea. It held that Parliament can amend the Constitution, but it cannot take away the very essence of what makes India a democracy. Things like the supremacy of the Constitution, the republican and democratic form of government, the secular character, the separation of powers, federalism, the independence of the judiciary, and indeed, many fundamental rights themselves, if they form part of this unshakable basic structure. It's like an unshakable foundation for the entire nation, even if the walls and roof can be renovated.
So even if Parliament wanted to, say, remove the secular nature of the country entirely or make the judiciary completely subservient to the executive, the basic structure doctrine would prevent it. This sounds like the ultimate safety net for democracy itself.
Precisely. Aspects like those you mentioned are generally considered part of this basic structure. Any amendment attempting to destroy these core features can be struck down by the judiciary, even if passed with the requisite majority under Article 368. It's a dynamic and living check on legislative power, ensuring the Constitution's soul remains intact. It was a masterstroke of judicial creativity to preserve constitutionalism.
And this crucial doctrine was further reinforced later on, wasn't it? It wasn't just a one-time thing in Kesavananda.
Yes, absolutely. In Minerva Mills Ltd. versus Union of India in 1980, the Supreme Court further solidified this. It struck down parts of Article 360 that had been inserted by the 42nd Amendment during the emergency period. Those insertions had attempted to grant Parliament unlimited amending power and complete immunity from judicial review, effectively trying to nullify the basic structure doctrine. The court reaffirmed that limited amending power and judicial review are themselves basic features of the Constitution. So Parliament couldn't even amend the Constitution to give itself unlimited amending power. It re-emphasized the enduring power and centrality of the basic structure doctrine. This raises an important question for you, listening right now. How does the judiciary's role as the ultimate interpreter, through doctrines like basic structure, ensure the enduring spirit of the Constitution, even when Parliament, which has a democratic mandate, tries to change it fundamentally? It truly highlights the delicate balance of power inherent in a constitutional democracy like India's.
Article 13, then, with its intricate doctrines like severability and eclipse, and its connection to the monumental basic structure doctrine through landmark judgments, is your constitutional safety net. It ensures that no law, no matter its origin or how it was passed, whether an ordinary law or even a constitutional amendment touching the core, can arbitrarily take away your most cherished rights or destroy the fundamental character of India. It's the ultimate guardian, giving teeth to every other fundamental right in the Constitution.
Article 14, the grand principle of equality.
Okay, so we've identified the who the state under Article 12 and the how laws are kept in check by Article 13, preventing them from eroding our fundamental rights, particularly through the basic structure doctrine. Powerful stuff. Now let's dive into the rights themselves, starting with the very foundation of fairness and justice. Article 14, the grand principle of equality. This is where the rubber truly meets the road in ensuring a just society for every individual.
Article 14 is absolutely the cornerstone of the rule of law in India. It establishes the general principles of equality before the law and equal protection of the laws. Think of it as the fountainhead from which other more specific equality rights, like those in Articles 15 and 16, emanate. It's broad, encompassing, and a powerful bulwark against arbitrary state action, ensuring fairness at every level.
And the text itself is remarkably concise. Article 14 simply states, "The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India."
That concise sentence holds immense power, guaranteeing equality in two distinct but complementary aspects. You need both for true equality. First, equality before the law, which is a concept largely borrowed from British jurisprudence. This is often seen as a negative concept.
Yeah.
It means the absence of special privileges for anyone. All persons are equally subject to the ordinary law of the land, administered by ordinary law courts. In essence, no one is above the law, from the highest officials to the common citizen. Everyone is accountable. This is about formal equality, no exceptions.
Okay, no one's above the law. And the second aspect, equal protection of the laws. How does that differ?
That's a concept more rooted in the American Constitution, and it's seen as a positive concept. It means equality of treatment in equal circumstances, or, as it's often put, like should be treated alike. This implies the state might actually need to make classifications for legitimate purposes to achieve substantive equality. It recognizes that treating unequal people identically can sometimes perpetuate inequality. Importantly, this right extends to any person, not just citizens. It covers citizens, non-citizens, natural persons, humans, and even legal persons like corporations. Its applicability is very broad, protecting everyone within India's territory.
So it's not about treating everyone identically, but allowing for sensible, well-reasoned distinctions. This is where it gets interesting, because treating everyone the same sometimes feels intuitively fair, but this suggests a more nuanced approach is actually required by the Constitution.
Exactly. That's a key takeaway. While class legislation, that is, discriminating within a class of people who are essentially similar, based on arbitrary differences, is strictly forbidden, reasonable classification is indeed permitted under Article 14. This means that for a law to differentiate between groups and still be constitutional, two conditions must be met. One, it must be based on an intelligible differentia, a discernible and understandable difference that distinguishes persons or things grouped together from others left out of the group. There must be a clear basis for the distinction. And two, this differentia must have a rational relation, nexus, to the object sought to be achieved by the law. The reason for the classification must logically connect to the law's purpose.
Can you give an example of that? Intelligible differentia and rational nexus.
Sure, think about progressive taxation. Higher income earners pay a higher percentage of tax. The intelligible differentia is a level of income clearly discernible. The rational nexus is the object of achieving economic justice and funding public services based on ability to pay. That's generally considered a valid classification under Article 14. However, imagine a law taxing people differently based on hair color or eye color. That would clearly lack both an intelligible differentia, why hair color, and a rational nexus to any legitimate state objective. It would be arbitrary and violate Article 14. That's the core test the courts apply, laid down clearly in cases like Ramkrishna Dalmia versus Justice S.R. Tendulkar, 1958. But here's where Article 14 truly evolved and expanded its reach significantly beyond just this classification test. Supreme Court expanded its scope to directly prohibit arbitrariness itself. The landmark case of E.P. Royappa versus State of Tamil Nadu in 1974 famously declared, equality is antithetical to arbitrariness. Any arbitrary state action is inherently unequal and thus violates Article 14.
Wow, so it's not just about what's written in the law, the classification itself, but how the state acts in practice. Even in executive decisions or administrative orders, this seems to put a much bigger, more active check on government power and how it operates day to day. It's not just about legislative acts.
Precisely. This new doctrine of equality, as it was called, was further affirmed and elaborated in Maneka Gandhi versus Union of India in 1978. Here, the court held that any state action which is not right, just, and fair is arbitrary and therefore violative of Article 14. The action must be reasonable. This makes the concept of equality under Article 14 incredibly dynamic, evolving to address modern governmental actions beyond just static legislative classification. For instance, an arbitrary award of a government contract, perhaps done without following a fair procedure or based on favoritism rather than merit, would clearly violate Article 14 because it constitutes an arbitrary state action, even if no specific law is discriminatory on its face. It ensures due process and transparency are key components of fair governance under the Equality Clause.
So, Article 14 truly is the foundational block. It ensures that every person, citizen or not, stands on an equal footing before the law. But more than that, it demands that the state itself acts with reason, with justice, and not with caprice or favoritism. It's the constant watch against unfairness in all its forms.
Article 15, Prohibition of Discrimination.
Okay, so building on that grand general principle of equality from Article 14, Article 15 gets very specific. It zooms in. It directly addresses historical and persistent forms of discrimination, particularly those rooted in deeply ingrained societal prejudices that have long plagued our nation, like caste, religion, gender.
Yes, and this raises an important question for you to consider as we look at Article 15. How does a constitution not only prohibit discrimination, but also actively enable positive discrimination, often called affirmative action or protective discrimination, to correct past injustices? Article 15 provides these specific answers, moving towards substantive equality rather than just formal equality. It acknowledges that sometimes, to achieve true equality, you need to treat people differently, to give some a leg up. It's a reflection of India's unique social challenges and its constitutional commitment to overcoming them.
Let's read out the key clauses of Article 15, because the details matter here. Clause 1 states, "The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them." Simple prohibition against the state. Clause 2 provides, "No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to A, access to shops, public restaurants, hotels, and places of public entertainment, or B, the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public." This seems to target social discrimination.
Exactly. And then we have the crucial affirmative action clauses, the exceptions that allow for positive steps. Clause 3 allows the state to make special provision for women and children. Clause 4, which was added by the very first amendment in 1951, allows special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. A hugely significant clause. And Clause 5, inserted much later by the 93rd Amendment in 2005, further provides for special provision relating to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause of Article 30. This tackled reservations in private education.
So at its core, Article 15 is a dual-purpose article, isn't it? Prohibiting certain kinds of discrimination, but also explicitly allowing others aimed at upliftment.
That's a perfect way to put it. It prohibits the state from discriminating against citizens on those specified grounds in Clause 1. But what's equally crucial is that it extends this prohibition to private individuals in public contexts through Clause 2. And importantly, it carves out explicit exceptions for what's known as protective discrimination or affirmative action through Clauses 3, 4, and 5, recognizing that mere non-discrimination isn't always enough to level the playing field historically.
Let's delve into those specifics again. For Clause 1, the prohibition on state discrimination applies only to seditions and on grounds only of religion, race, caste, sex, or place of birth. That word only seems critical.
The word only is incredibly crucial here, and the courts have emphasized it repeatedly. If discrimination by the state is based solely on one or more of these 5 grounds, it's unconstitutional under 15.1. But if other grounds are involved in addition to these, or if the differentiation is based on other grounds entirely, say, residence for certain benefits or specific qualifications for a job, it might not be hit by 15.1 directly. Of course, Article 14's general prohibition against arbitrariness could still apply if the action is unreasonable, but 15.1 is very specific. So a state circular denying government jobs only based on religion would be a clear and undeniable violation of 15.1.
And Clause 2 about public places is really interesting because you said it has horizontal application. What does that mean in practice? It feels like it directly addresses societal ills, not just government actions.
Indeed, this is a significant and powerful feature of Article 15. It has horizontal application, meaning it prohibits any person, not just the state, but also private individuals or entities like shop owners or restaurant managers from discriminating on these grounds, religion, race, caste, sex, place of birth, regarding access to certain public places. These include shops, public restaurants, hotels, places of public entertainment, and also the use of wells, tanks, bathing ghats, roads, and other public resorts maintained wholly or partly by the state or dedicated to the public. This was a revolutionary step in tackling deeply ingrained social evils like untouchability and segregation directly.
So this clause directly tackles social evils like untouchability, even if practiced by private individuals in public spaces. That's a huge step toward real-world, tangible equality. Imagine a private restaurant refusing entry based solely on caste, or a village community denying access to a public well based on someone's religion. Those are direct violations of Article 15.2. It makes the Constitution a tool for everyday social justice, right where people live.
Absolutely.
Yeah.
It aims to dismantle social barriers in public life. And then we come to the enabling provisions for affirmative action, or protective discrimination. Clause 3 allows the state to make special beneficial provisions for women and children, for example, laws providing maternity benefits for working women, reserving seats for women in local bodies like panchayats or municipalities, or even establishing special educational programs for girls. These are clearly designed to address historical disadvantages or specific needs related to gender and age.
And Clause 4, that was added really early on by the First Amendment.
Yes. Clause 4, added by the First Amendment in 1951, enables the state to make special provisions for the advancement of socially and educationally backward classes, SEBCs, scheduled castes, SCs, and scheduled tribes, STs. This was a direct legislative response to the state of Madras versus Champakanpakamtorajan case in 1951. In that case, the Supreme Court struck down caste and religion-based quotas in state educational admissions, finding them contrary to Article 15.1 and Article 29.2. Clause 4 was Parliament's way of saying, okay, while we prohibit discrimination generally, we need the power to make special provisions to uplift these historically marginalized groups. It demonstrated the Constitution's adaptability, showing how a judicial ruling can directly lead to a constitutional amendment to further the goals of social justice and correct perceived legislative limitations.
So the Constitution itself evolved to explicitly allow for affirmative action in response to a court ruling. Fascinating. And then even later, Clause 5 came along, specifically for educational institutions, which also stirred significant debate, didn't it?
Yes, much later. Clause 5, inserted by the 93rd Amendment in 2005, allows special provisions, including reservations, for these same groups, SEBCs, SCs, and STs, in admissions to all educational institutions. Critically, this includes private educational institutions, whether they receive government aid or not. This was a major extension of reservation policy into the private sector. However, it excludes minority institutions, which have specific protections under Article 30. This clause addressed challenges arising from cases like TMA Pay Foundation versus State of Karnataka, 2002, and PA Inamdar versus State of Maharashtra, 2005. These cases had dealt with the autonomy of private educational institutions and cast doubt on the state's power to impose reservations on them. Clause 5 clarified the state's power in this complex area, balancing private institutional rights with the imperative of affirmative action. For example, a law mandating private unaided engineering colleges to reserve seats for SEBCs would derive its validity directly from Article 15.5.
What's the overall significance here when we look at Article 15 as a whole, with its prohibitions and its exceptions?
Article 15 is a powerful engine for social reform, driving a transition from merely formal equality, treating everyone the same, to substantive equality, achieving genuine equality of outcome and opportunity. It does this not just by prohibiting discrimination on specific immutable grounds, but by actively promoting conditions for true equality, by allowing the state to uplift historically disadvantaged communities through special provisions. It's the Constitution's way of saying, formal equality isn't enough in a society with deep historical inequalities. Sometimes you need to provide extra targeted support to those who've been systematically left behind to help them catch up. This dynamic pursuit of equality is what makes it so pivotal, and its application continues to evolve. A recent powerful example of Article 15's spirit is Joseph Shine versus Union of India, 2019, which struck down the archaic adultery law, Section 497 of the IPC. The court found it violated Articles 14 and 15, partly because it discriminated based on outdated gender stereotypes, treating women as property of men. This highlights the ongoing effort to root out discrimination in all its forms, using Article 15 as a key tool.
Article 15 is truly a testament to the idea that the Constitution is not static, but a living document capable of addressing deep-seated societal inequities and pushing for a more inclusive future, even if the path is complex and debated.
Article 16, equality of opportunity in public employment.
Right. From general equality in Article 14 and specific discrimination prohibitions plus affirmative action in Article 15, we now zoom in on one of the most visible and often intensely debated arenas of equality. Public employment, which is addressed by Article 16. This is where countless lives are directly affected and where the concepts of individual merit and collective social justice often meet, sometimes quite contentiously.
Absolutely. Article 16 is another specific and highly significant application of the general principle of equality enshrined in Article 14, but it focuses squarely on equal opportunity in government jobs and offices under the state. It navigates the complex terrain of balancing individual merit, ensuring fairness for all applicants, and promoting efficiency with the imperative of addressing historical underrepresentation, striving for a representative bureaucracy that truly reflects the diversity of the nation. This is a delicate and often contentious tightrope walk, legally and socially.
Let's read the key clauses of Article 16. It mirrors 15 in some ways, but has crucial differences. Clause 1 states, "There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state." The basic guarantee, Clause 2, elaborates, "No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state." Notice the extra grounds here compared to 15.1, descent and residence. Then come the exceptions and affirmative action provisions. Clause 3 permits Parliament to make laws prescribing residence requirements for certain state jobs. Clause 4 allows reservations for any backward class of citizens, which, in the state's opinion, is not adequately represented in public services. This is the big one for job quotas. Clause 4A, added later by the 77th and 85th Amendments, allows for reservation and promotions for SC/STs, crucially including consequential seniority. Clause 4B, added by the 81st Amendment, allows for the carry-forward rule for unfilled reserved vacancies, preventing the 50% limit from being breached by backlog quotas. And Clause 5 allows exceptions for the incumbent of offices related to religious or denominational institutions.
So Article 16, at its core, makes a clear guarantee: equality of opportunity for all citizens in public employment. It explicitly prohibits discrimination on those specified grounds listed in Clause 2. But crucially, just like Article 15, it also allows for affirmative action, primarily through Clause 4 and its subsequent additions 4A, 4B, in the form of reservations. This is aimed at ensuring adequate representation for disadvantaged groups who might otherwise struggle to compete effectively due to systemic historical disadvantages.
So equality of opportunity under Clause 1 applies to all citizens and covers a vast array of matters related to employment, everything from the initial application and interview process through promotions, transfers, determining seniority, determination, and even salary and pensions, right? It's a comprehensive guarantee.
Indeed, the phrase matters relating to employment or appointment is interpreted very broadly by the courts. Clause 2 then prohibits specific discrimination on grounds of religion, race, caste, sex, descent, place of birth, or residence. As you noted, this list is broader than Article 15.1, with the explicit inclusion of dissent and residence. This is significant, specifically designed to prevent more subtle or localized forms of exclusion, like favoring locals over others or discriminating based on lineage. For example, a government job advertisement specifying only male candidates for a role where gender isn't a bona fide occupational requirement would be a clear violation of Article 16.2. Similarly, a rule giving preference based on ancestry or state residence, unless specifically permitted by Parliament under Clause 3, would also fall afoul of 16.2.
Okay, and what about those exceptions for affirmative action and other special provisions? This is where the complexities truly begin, particularly around reservations, which is probably the most litigated aspect of Article 16.
Precisely. Clause 3, for example, allows only Parliament, not state legislatures, to make laws prescribing residential qualifications for certain categories of state or local government jobs. This is a deliberate design feature to prevent states from creating overly parochial barriers to employment and to maintain a sense of national unity in public services, though Parliament has used this power sparingly. Then, Clause 4 is foundational, empowering the state, which could be the central or state government, to make reservations in appointments or posts in favor of any backward class of citizens, which, in the opinion of the state, is not adequately represented in the services under the state. This is the primary constitutional basis for job reservations in India for OBCs, other backward classes, SCs, and STs, a direct response to historical social hierarchies and unequal access to education and opportunity. The terms backward class and adequately represented have, of course, been subject to immense judicial interpretation.
And then came the additions 4A and 4B dealing with promotions and backlog vacancies. Those seem like responses to specific problems that arose with implementing Clause 4.
Exactly. They reflect the ongoing adjustments needed to make affirmative action work effectively and fairly. Clause 4A, inserted by the 77th Amendment in 1995 and later amended by the 85th Amendment in 2001, specifically allows for reservation and promotions for scheduled castes and scheduled tribes if the state feels they are underrepresented at higher levels. This is a critical addition because it also includes consequential seniority. This means if an SC/ST candidate is promoted earlier than a general category colleague due to reservation, they might retain that seniority throughout their career, which can significantly impact future promotions and career progression. This was a legislative response to judicial rulings, particularly in Drasani, which had initially restricted reservations to initial appointments only.
And Clause 4B, addressing the carry-forward rule, sounds like it's designed to ensure these quotas actually get filled over time without disrupting the overall balance too much in one go.
You've hit on its core purpose. Clause 4B, added by the 81st Amendment in 2000, addresses the carry-forward rule for unfilled reserved vacancies. It allows unfilled reserve vacancies from one recruitment year to be carried forward to subsequent years and treated as a separate class of vacancies. This is crucial because it prevents these backlog vacancies from being clubbed with the current year's fresh vacancies when applying the general 50% ceiling on total reservations, established in Indrasani. It ensures that the reserve quota aims to be eventually met over time, without exceeding the judicial limit in any single year. It's about achieving cumulative representation effectively.
And finally, Clause 5 carves out that very specific exception for religious institutions similar to some aspects of Article 15.
Yes. It permits laws requiring the incumbent of an office connected with the affairs of any religious or denominational institution, or a member of its governing body, to profess a particular religion or belong to a particular denomination. For example, a law requiring a temple priest employed by a statutory board managing the temple to be Hindu would be permissible under Article 16.5, recognizing the unique nature and requirements of such roles. If we connect this all to the bigger picture, Article 16 truly highlights how the Constitution doesn't just prohibit discrimination, but actively empowers the state to correct historical disadvantages and ensure genuine representation in its own workforce. However, it does so within a framework that requires a complex legal and judicial tightrope walk, balancing equality of opportunity for all, the need for representation for marginalized groups, and the overall requirement of maintaining administrative efficiency, as mentioned in Article 335. The identification of backward classes, the determination of adequate representation, and the application of the creamy layer concept are constantly subject to judicial scrutiny to prevent arbitrariness and ensure the benefits reach the truly deserving.
And this complexity is perfectly illustrated by the landmark case law on reservations under Article 16. It's a saga of ongoing legal and social debate that has truly shaped modern India, hasn't it?
It is indeed a complex tapestry, a constantly evolving story. Early on, in General Managers, Southern Railway versus Rangachari, 1962, the court interpreted the scope of matters relating to employment in 1671 broadly to include promotions, and initially interpreted 1604 to allow promotion reservations. Later, State of Kerala versus N.M. Thomas, 1976, took a broader view, suggesting 1604 wasn't just an exception to equality, but an instance of classification aimed at achieving equality, allowing for reasonable classification even outside 1604. But the seminal judgment, the one that profoundly shaped reservation policy for decades and continues to be the bedrock, was Indrasawny versus Union of India in 1993, famously known as the Mandal Commission case. A massive 9-judge bench delivered this verdict. It upheld the validity of reservations for OBCs in central government jobs under Article 16.4 based on the Mandal Commission report. But it did so with critical conditions and clarifications. It elaborated on how to identify backward classes, using caste as a factor alongside other indicators like social and educational backwardness, introduced the crucial creamy layer exclusion, ensuring that the more affluent sections among the backward classes do not corner the benefits meant for the truly disadvantaged, and generally set a 50% ceiling on total reservations in any given year. Critically, the majority in Indrasawny held that reservation under Article 16.4 applied only to initial appointments and not to promotions. This specific ruling directly led to Parliament enacting the 77th Amendment, which inserted Article 16.4a to specifically override this part of the judgment and allow for reservations in promotions for SCSSTs.
So Parliament had to amend the Constitution twice, 77th and later 85th for seniority, to explicitly allow for something the Supreme Court had just ruled against in Indrasawny regarding promotions. That truly shows the dynamic, sometimes tense interaction between the judiciary interpreting the Constitution and the legislature responding to perceived social needs.
Absolutely, it's a classic example of that dialogue. The judicial pronouncement in Indrasawny restricted Parliament's perceived power on promotions based on its reading of Article 16.4, and Parliament responded by amending the Constitution itself to grant that power explicitly, which then had to face further judicial scrutiny regarding its own validity. In M. Nagaraj versus Union of India, 2006, the Supreme Court upheld the constitutional validity of Articles 16.4a, promotion reservation for SCST, and 16.4b, carry forward rule. However, it didn't give the state a blank check. It stipulated 3 controlling conditions for making reservations and promotions under 16.4a. The state must collect quantifiable data showing the backwardness of the class and inadequacy of representation of that class in public employment, and it must ensure that overall administrative efficiency, as per Article 335, is not compromised. It placed a significant burden of proof on the state before implementing such quotas.
And the saga continued even further with the creamy layer principle being debated for SCs and STs in promotions too, right? Indrasawny applied it to OBCs, but what about SCSTs?
Yes, that became the next major point of contention. In Jurnal Singh versus Lakshminarayan Gupta, 2018, the Supreme Court revisited the Nagraj conditions. It affirmed the need for data on inadequacy of representation and the need to maintain administrative efficiency. However, it modified Nagraj by clarifying that quantifiable data on backwardness is not required specifically for SCSTs when considering promotions, as their backwardness is presumed constitutionally. But importantly, this judgment extended the creamy layer principle, excluding the affluent, to SCSSTs in the context of reservations and promotions as well. The logic was that the benefits should go to the weakest of the weak within these groups, preventing the already well-off among them from cornering all the reserved posts. This remains a highly debated aspect.
Article 16 clearly reflects the ongoing societal debate, the deep tension between striving for individual merit and equal opportunity for all versus the compelling need for collective upliftment and representation for historically marginalized communities. It tries to forge a path towards genuine equality of opportunity in a vast, diverse, and historically stratified nation like India. It's a constantly evolving area where legal principles meet complex social realities, and the judiciary continuously fine-tunes the balance, often leading to further legislative responses. It's never static. #outro. Wow, what a journey we've had today. We've really navigated the intricate definitions of the state under Article 12, explored how Article 13 acts as that powerful guardian of your fundamental rights, especially with the basic structure doctrine, and then dove deep into the many facets and nuances of equality through Articles 14, 15, and 16. It's a complex but incredibly vital tapestry of legal protections that underpin our entire democratic system.
Indeed. And it's crucial to see how these articles aren't isolated provisions. They are deeply interconnected, forming a comprehensive framework for liberty and equality. Articles 12 and 13, you could say, define the playing field and the rules of the game for fundamental rights, detailing who is accountable and how laws themselves are kept in check. Meanwhile, Articles 14, 15, and 16 operationalize or put into action the principle of equality. They translate that broad ideal into concrete protections, striving for a more just and egalitarian society by addressing general equality, specific forms of discrimination, and the particularly sensitive area of public employment and affirmative action.
And understanding these fundamental rights isn't just for legal scholars or lawyers, it's for you, for everyone. These are the constitutional promises that directly shape your daily life, whether it's challenging an arbitrary decision by your local municipality, ensuring fair opportunities if you apply for public service, or fighting social discrimination in its various forms, whether it's practiced by the state or even sometimes by private actors in public spaces. This knowledge is your power, really. It enables you to better understand the world around you and your place within its constitutional framework.
Absolutely. This knowledge empowers you to understand the spirit of your Constitution, to question assumptions about fairness and equality, and perhaps to appreciate the constant dynamic effort required to uphold these cherished ideals. It's a living document, and its interpretation and application are continually evolving to meet the needs of a changing society, reflecting its ongoing aspirations for justice for all its people.
So, if these articles 12 through 16 were designed primarily to address the inequalities and challenges of their time back in the mid 20th century, here's a thought for you to mull over. As our society evolves so rapidly now, with new technologies like artificial intelligence potentially impacting employment opportunities in unprecedented ways, or new forms of social discrimination perhaps emerging online or through data, what further challenges might arise in upholding these foundational principles of equality, non-arbitrariness, non-discrimination, equal opportunity in the years to come? How might these foundational articles be tested or reinterpreted to truly achieve the equitable society we are still striving to build in the 21st century and beyond? Something to think about. Keep exploring, keep questioning, and keep that curiosity alive. This has been The Deep Dive, and we hope you're leaving today feeling a little more informed and perhaps a lot more curious about the amazing document that governs us all and protects our fundamental rights.